afternoon, everyone. Thank you very much for joining us. My name's David Friedman. I'm a lawyer at Wagner Sidlowski, and I also teach law at Queen's. And I'm the co-chair for this Lunch and Learn series on issues in family and estate law, together with my colleague Peter Neufeld. For those of you that don't know Peter, he's a partner at Wagner Sidlowski, and he litigates in estates matters as well in general commercial practice. The topic that our speakers will be addressing today, is an update on estate freezes for beginners with reference to litigation issues. In the chat bar, you'll find a few documents. A paper written by Charles Wagner and Greg Sidlowski on estate freezes. A document that has been created by our speakers, which you probably would do well to open up and have before you while they speak, respecting the issues and some of the law on point. And there'll also be a certificate of attendance that you can download for your participation in the seminar today. May I ask you if you would please have your microphones muted at all times, unless you're asking questions at the end of the presentations, and after you've asked your question, if you could mute yourself again, I'd be grateful. We have three presenters today. Clare Burns is a partner at WeirFoulds. Clare's a very well-known lawyer, a former children's lawyer for the province. Clare's practice focuses on estates, trusts, and guardian or capacity litigation, excuse me. She's written extensively on various topics in these areas. She appears regularly at continuing education events, and she's, as I said, very well known through the profession and very well regarded. Jonah Waxman is a partner in the Wills, Trusts, and Estates practice group at WeirFoulds. He's a litigator with expertise in trust estates and capacity litigation. He's also got considerable experience outside of this area in litigation. Like Clare, Jonah has participated as a speaker in many CPD events, and recently he participated as an instructor in the Osgood Certificate in Estate Litigation. Adam Prewer is a partner at Epstein Cole. He practices exclusively in the area of family law before courts and in arbitrations and all manner of disputes involving family law. He's also a co-author of Unpacking Family Law for Practitioners, which is published by LexisNexis. I'd like to thank our sponsors, Scotia Wealth Management, B'nai B'rith, Epstein Cole, Concentric Trust, BMO Private Wealth, TD, Torque and Mains, Solus Trust, and WeirFoulds. This event is complimentary through their generosity. If you enjoyed our seminar, we would ask you to consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. And there should be a link to that in the chat either now or at some point soon. Elite Mannheim is the manager of legal affairs for B'nai B'rith Canada, and she's here with us today. And I would ask Elite if you perhaps could say a few words about B'nai B'rith and its charitable work.
Absolutely. Today I'm actually going to talk a little bit about our initiatives. On November 5th, B'nai B'rith Canada warranted a House of Commons Standing Committee that a two-state solution to the Palestinian-Israeli conflict would not be possible without major democratic reforms in the Palestinian territories. In a 5-page submission to the Standing Committee of Foreign Affairs and International Development, FAAE, B'nai B'rith wrote, among others, that the peaceful coexistence of an Israeli and Palestine state is the only logical solution. However, it would be irresponsible to recognize Palestine statehood under the current circumstances. Rushing the development of the framework for a two-state solution has the potential to only further jeopardize Israeli national security. Thus, Naybrid argued that Canada should commit to assisting in the development of functional democracy within the Palestinian territories before it recognizes the existence of the Palestinian state. Taking this step preemptively before Palestinian institutions are capable of self-governance could lead to a repetition of a civil war such as the one that embroiled Gaza following Israel's withdrawal from territory in 2005. On Tuesday morning, November 5th, Naybrid, Regional Director of Quebec and Atlantic Canada, who presented our organization conclusions to FAAE, said during the committee's 125th sitting that Iran-backed terrorist organizations such as Hamas and Hezbollah are major obstacles to democratic reforms in the Palestinian territories. Canada must give Israel its unconditional support so that it has space to eliminate terrorist threats to its security. Such radical Islamic groups are not only a threat to Israel and the global Jewish community, but also are autocratic death cults that violently suppresses expansions of dissent in the Palestinian public life. Nabrith's appearance at the FAAE comes as Israel continues to battle Hamas in Gaza Strip, where the terrorists still hold about 100 hostages abducted during their brutal assault on Israel on October 7, 2023. In the past few months, Israel has also faced an unprecedented series of attacks launched by the Islamic Republic of Iran. David Gornowski, Nabrith Canada's Director of Government Relations, has said that the Jewish community generally wants peace, and Canada can be a part of the process of helping Israelis and Palestinians reach a lasting compromise. But it is far too early to consider recognizing a Palestinian state, and doing so would only give legitimacy to terrorists. Rewarding terrorism is inconsistent with our country's liberal values. It is also a poor strategy as it would harden existing tension in the Middle East and spill over into incitement of hatred abroad, including in Canada. Thank you for your time.
Thank you very much, Elite. If I could now turn to our presenters. Claire, I understand that you're going to lead off, and it's all yours.
Thanks, and good afternoon, everybody. So we're going to talk about estate freezes in the context of litigation, just to refresh everybody's memory as to what an estate freeze is and the context in which it comes up. A freeze is a corporate transaction where it is decided to quantify the current value of a corporation and to fix that value by issuing preference shares in place of the existing common shares to, in the ordinary course, the founder, and then to issue new common shares, which will contain effectively all the future growth of the corporation, and pass those common shares either into a trust, that's the most common structure that's done, for future generations, or to actually distribute it to future generations. And you might say, well, that's not really relevant to the kind of practice that I have, but I will tell you that in the days when real estate is rapidly increasing in value, and many professionals, for example, have their practices in pieces in homes or refurbished homes or small office buildings, which they've purchased at the start of their careers, it's not uncommon to see those people entering into freeze transactions in order to push down the future growth of the real estate to future generations. Rather than talk about, however, accountants or lawyers today, We have set up a fact pattern which contemplates a small business owner. In this case, the client is a man named Otto. He owns Otto's Auto Body, an auto parts corporation that has family roots dating back many generations. He's the sole shareholder. He owns 100 common shares. In terms of his personal life, he's married to Rachel, with whom he has 2 adult children, Daniel and Otto Jr. Unbeknownst to the family, Otto is also having an affair of a long-standing nature with his receptionist, Becky. So just again, you've got Otto married to Rachel, 2 adult children, Daniel and Otto Jr., and the woman in the background, Becky. So a week ago, a real estate developer approached Otto with an offer to purchase the land on which the business operates and put up a high-rise condo in its place. The offer is for $10 million, a very tempting proposal for Otto, but with significant tax exposure. So Otto goes to speak to his accountant, Jim, who recommends that he does an estate freeze. So in essence, what Jim is suggesting is Otto will exchange his 100 common shares for preferred shares, with a fixed current value. They will give the new common shares to Otto Jr. only because Otto Jr. has been working in the business. And Otto will enter into an agreement with Isaac, with Otto's and with the corporation, selling 50% of the land, but retaining a 50% ownership interest so that Otto Jr. continues to benefit from the increased land value when the condominium project is built. Jim took a law class in high school, and he feels he's really qualified to assist Otto with the deal. And Otto's lawyer, regrettably, has only done his research on Wikipedia and loves new challenges. So he proceeds to implement this plan with a total disregard for the possible interests of Otto's wife, Rachel, and Otto's other adult child, Daniel, who we can all agree is not going to be best pleased to find out that Otto Jr. is getting all the future growth in the family business. And obviously, we know Becky's going to be out of work once this project starts to get built, because there will be no need for a receptionist at the auto body shop. However, we're not dealing with Becky's employment law questions today. That is a different seminar where you'll have to go to. We're going to talk about things to consider in an estate freeze, and I'm going to hand it off to my partner, Jonah, to talk about that in general terms. Over to you, Jonah.
Thanks, Claire, and good afternoon, everybody. So as Claire mentioned, we're going to be speaking to the challenges, or how one might challenge an estate freeze, and some things that you may wish to consider. So a party may wish to challenge this sort of structure or this reorganization for a variety of reasons, as you can imagine, including, for example, that the reorganization may have stripped or reduced one party's inheritance with the growth going to another party. So if you take our scenario and you think about how poor Daniel might feel getting none of the growth shares. Now imagine that rather than Otto Jr., Daniel was the one who was financially supporting his father and working in the business. Or imagine how Otto's partner might feel if they were to separate 10 years post estate freeze, with the growth shares having been transferred to Otto Jr., with that partner alleging a lack of independent legal advice from the lawyer or from anybody for that matter. And you can see through the fog of this example, or the scenario, potential allegations of undue influence that may arise, allegations of a lack of knowledge or understanding of how an estate freeze or the consequences of the estate freeze, or claims in equity for constructive trust by other family members. So what we're going to do today from a high level is look at this, is review 3 conceptual lenses through which to frame these challenges to an estate freeze. Those being the lack of independent legal advice, deficiencies in terms of the minute books of the corporation, and claims that may be brought against third parties for implementing the estate freeze or the advice that was provided. So we're going to look first at the issue of independent legal advice. And this is going to be especially relevant when we look at claims that might be advanced against third parties, whether they be the lawyer involved who, had done all of his research on Wikipedia, or the accountants who may have, for example, not properly coordinated with the lawyer or other deficiencies in terms of how they've implemented this freeze. So this first lens, if you will, is going to be a primer to that subsequent discussion of these claims against third parties. And what I want to do on this topic is look at both to whom independent legal advice is owed, and second, what is the scope of that potential, or what is the scope of what should be provided in terms of independent legal advice? So on the first question, as in to whom ILA is owed, there's general questions that arise in terms of, has the lawyer, for example, provided or recommended independent legal advice to a spouse or to the children, so to either Daniel or Otto, or rather recommended independent legal advice to these parties, who might be in these circumstances losing control or whose interest may be fixed by this freeze. So there's family law implications to the freeze, certain family law rights, including issues with respect to joint family venture that Adam will be talking about momentarily, as well as issues relating to capping the value of certain beneficiaries' entitlements following an estate freeze. So, for example, you might have a situation where poor Daniel, in this case, might sue in oppression because he was ousted from any opportunity to control the business or to own growth shares. And he might argue that Otto Jr. unduly influenced Otto in giving him all of these growth shares. So I might first turn it over to Claire and Adam as to who else besides a spouse or the children might be entitled to receive independent legal advice in this circumstance.
Adam, would you like me to pick it up first?
You can probably pick it up first, as we've covered
Okay.
two categories of people that I'm wanting to talk about.
Okay, so the people in the scenario that we described that are not on the radar screen for independent legal advice are potentially Otto Jr.'s spouse and Daniel's spouse. So it may be, for example, just to complicate our example slightly, let's say that when the boys had turned 18, Otto Sr. had issued each one of them a common share in the business. So that now, in order to accomplish the freeze, all the common shares have to be turned into preference shares. So the boys are being asked to agree to a series of corporate resolutions in which their shares are going to get converted to preference shares, fixing the value that they currently own in the business. If they are already married, their spouses may have rights in that regard, and I'll leave it to Adam to talk about spouses generally. The really tricky one, if you're the lawyer for Otto Sr. here, is what to do about Becky if you know about the mistress situation. And I know from 30 years of practice that often the local solicitor who's acting for the founder in the business is perfectly aware of their overlapping or extramarital conduct. And so here, Becky does have a claim against Otto Sr., particularly when Otto dies. If he's been supporting her under Part 5 of the Succession Law Reform Act, Becky might bring a dependence relief claim. Ideally, you'd want to tidy up the mess now with Becky and make some deal with her to have her release that interest. It may not be practically possible because that might involve having to have Rachel find out about Becky, which won't be good for anybody, I'm guessing. But it is something you should have on your radar screen if you are the lawyer acting on the freeze. In particular, you should be telling your client that Becky has future claims and that might affect the validity of the freeze going forward. That should be in your reporting letter if at the end of the transaction, just so that 20 years from now, when Otto Sr. dies and Becky comes for her share of the pie, you have a defense when Law Pro comes to represent you about what advice you did or didn't give. Adam, as you know, I try to know as little as possible about family law, so I'm going to kick it over to you to talk about that.
Thank you. If other lawyers learned about family law, I'd be out of work. So I always appreciate other people's ignorance. In terms of estate freezes, when we're considering this from a family law perspective, it really comes in sort of two ways. It's generation 1 and generation 2. And generation 1 is, in this case, Otto Sr., the person who is in control and is sort of causing the freeze. The person that you really want to think about in terms of ILA here is Otto's spouse. And oftentimes, this individual can sometimes be ignored, or lawyers performing the freeze, oftentimes sort of, I've seen this in large institutional law firms, they sort of have the view that they'll tell everybody what they need to know. And if you represent the spouse, I have heard time and time again, I was invited into the lawyer's office. They told me to sign a piece of paper. I signed it. And that's not going to work. So what becomes very important in estate freezes in family law, in general, we are analyzing the growth during a marriage. That's each person's net family property, and they share half the difference of their growths. And in an estate freeze, one could argue that Otto Sr. is sort of giving away a huge portion of his asset base that he would normally have to equalize. Now, if Rachel is aware of that, she is on board with this gift to their child or children, then that can be completely acceptable. Great. The law will support that and get behind that. But we want to make sure that Rachel knows essentially how this is going to impact her equalization payment of net family property, and that it is very clear on the record that she is aware of that impact and she's supportive of it. If that isn't present and it's essentially done without her knowledge or without a full appreciation, Otto Sr. sets himself up as having a potential vulnerability, as in the event of separation, Rachel could claim an unequal division of net family property, essentially saying he denuded himself of these assets. I had no idea he was doing it. I didn't find out until we separated. And that is sort of a worst case scenario for Otto, because now he's carrying this immense family law risk, but he has moved those common shares away from himself. A bad scenario, and one that can be very easily avoided, just ensuring that Rachel has proper legal advice. The issue of sort of the mistress is one that it looms in a lot of family law cases, and some of their rights and obligations can be a little bit murky. However, what would be really clear here and be important to get ILA for Becky is that Becky has a claim in trust to an interest in Otto's business due to all of her sort of uncompensated efforts. And you would certainly want to clean that up before the freeze happens. Again, you're just avoiding these ticking time bombs. And that's that sort of first generation. In terms of the second generation and the considerations there, the long and the short is on all of this, the kids are going to need very clear ILA and a fair bit of planning as to how this is going to happen. Under the Family Law Act, a gift received during the marriage is excluded. It's not subject to equalization. And it's important that when you are thinking of this freeze structure, you have good family law advice. I have seen people do freezes where the gifting portion of those common shares is unclear. I had one file where everything got very complicated because rather than gifting the common shares directly to either a trust or the child themselves, it was gifted to a child's corporation. because the child wanted to do that for tax reasons. And I'm sure it seemed like a very good tax response at the time, but then we had a hell of an issue when it came time to sorting that out because the adult child had not received a gift. The corporation had. So those sorts of family law considerations for the kids really need to be looked at very carefully. The example that Claire had just put forward, which again would be an important part, if the kids have an existing interest in the company, one that predated marriage, it's very important that their spouses are sort of brought in. It's never a bad idea to ensure that the spouses have as much information about this freeze as possible. Yeah, a lot of families are very awkward about this. They sort of don't want to extend that information. A lot of business people are used to dealing with things that way. They keep their information close to the vest. But in this case, the more information, the more people have independent legal advice, sort of the better for the durability of the freeze from a family law perspective.
So I just wanted to pick one thing up that you said, Adam, and that's about the ILA itself. And my issue is, or my question is, do you have any tips for the person who's actually doing the ILA in terms of good defensive practice tips? So let's say I call you and say, hey, Adam, I need ILA for Rachel here. What kind of things are you just going to say, hey, bad news, Rachel, 50% is going out, or what are you going to say?
So I've been in that situation before, and I will sort of say the number one thing you can do when you are asked to be that ILA is, how do I phrase it? Don't be too polite. Make sure you are getting the disclosure. And what I've done is I walked my client through the calculation. So if you separate it today, there's no freeze. This is what you're going to get. If you were to agree to the freeze and sort of run some hypotheticals, this is how far it's gone. I've also spent some time looking at the work the accountants have done to value the pref shares. That can also sort of be one of those ticking time bombs, which is the accountant can perform an estate freeze, put a value on the pref shares, but if that value isn't accurate and supportable, a family law judge is not compelled to be stuck with it down the line, which a lot of people can be somewhat surprised to find out. And they say, well, my pref shares are worth $500,000. That's what we set the value at. I'm like, yeah, but you did a crappy valuation then. So we're not stuck with it now. So when I'm in sort of the Rachel lawyer's shoes, I deal with it like any marriage contract. I want to see all the disclosure, and I want to make sure that Rachel knows everything that she could get and is choosing perhaps not to get, and to make sure that she understands exactly what's going to happen.
So I assume you do a reporting letter and keep lots of detailed notes, right?
I've done enough Law Pro files now to know, memos to file, reporting letters, those emails. Maybe this is just a generational gap. What I prefer to do, rather than I do like the big formal reporting letters, but what I really like to do is just, as soon as I'm done having a substantive phone call with someone about something like this, I fire off an email, further to our phone call, here's just a quick summary.
Right. I think that's a great defensive practice. And I assume you keep similar notes around your conversations with the accountants.
Yes, well, those tend to be, I tend to like to keep detailed notes with the accountants just because I tend to want to read it over a few times afterward. It's sort of like, okay, initially sounds good, but reading over it a couple of times afterward, being like, maybe I have a few more questions about the methodology here.
Yeah, and I think it's really important for the lawyers on this call to know that my rule is that if I don't understand it, I'm not going to be able to explain it to a judge in the future. So There is no question too dumb for Clare Burns to ask an accountant. If I don't get it, I'm just going to keep asking until I understand it, because having a note in your notes that says something along the lines of, and I've seen this, valuation methodology is satisfactory, is not going to get you anywhere when you are defending yourself against a negligence claim when you're the person who gave the ILA. So we're going to move on topics, I think, Adam, if that's okay with you.
Yep, absolutely.
And I'm going to kick it back to Jonah, who's going to start with my favorite piece of evidence in these cases, which is the minute books. Jonah, back to you.
Thanks, Claire. Thanks, Adam. And just as a rider to what you were both talking about in terms of addressing claims with Becky off the top, I think it's just as an aside, it's important to deal with. It may be important to deal with that proactively, because if a party were attempting to sweep that under the rug, if you will, and deal with it in the context of that person's estate through an in terrorem clause or an effort to disentitle them from bringing like a Part 5 SLRA dependent relief claim, that could be considered invalid because those could be contrary to public policy. So it just dovetails with Claire's point about the possibility of needing to deal with Becky's claim then and there, and to obtain the appropriate independent legal advice. So with that, we're going to move on to the second topic, which is the second topic through which an estate freeze can be attacked, and that is the review of the corporate minute books. And one thing that is very important in any sort of litigation is the need to obtain the minute books from the date of incorporation, and not just as of the date of the freeze, because you don't know what has happened before then and what resolutions have been passed and in what order. So when we look at the minute books of a corporation, you might find certain interesting developments that are concerning. So, for example, we have a case right now where a lawyer attempted to implement an estate freeze, and as we mentioned off the top, the mechanism is you exchange common shares for fixed value preference shares. In this case, there were no common shares issued at all. So there were no growth shares issued. And that is something that we uncovered and learned through a thorough review of the minute book from the date of incorporation. And that has led to this consideration as to what the accountants and what the lawyers have done in this case. Because it seems like what they've done is they've transferred the common shares for preference shares, but allowed no growth potential, as was intended or contemplated through the estate freeze. And it brings up interesting questions of negligence against the professionals, including the lawyers who set up this faux freeze. I understand that Claire may have some other examples in terms of what might be reviewed when a minute book is carefully considered.
Yeah, so just to give you another example that we've seen in our practice, and I would say it's very common to be in a situation where minute books have not been properly maintained by the founder, annual resolutions are not there, etc. So I couch the example I'm about to give you in that context. We did a case where the corporate solicitor decided that the resolutions had been misdated in respect of the estate freeze and the order in which the steps were taken. So he elected to use liquid paper, which, if there's anybody born in the last 25 years, you may not know what liquid paper it is. But for the rest of us, it's when you messed up your notes and you painted over it with white stuff called liquid paper and rewrote over the top. So we had a case with a minute book where the solicitor decided that he would fix this situation by liquid papering over the original dates and putting in the correct dates and times for the steps with pencil. So, needless to say, I had an enormous amount of fun in that case dealing with Law Pro Counsel, who attempted to explain why the liquid paper was just ordinary course business. So, it is a fundamental rule in our office. Every piece of litigation we do involving corporations, we always get the minute books. And we always have them reviewed by corporate counsel or a corporate law clerk. Where we're in the position where we have, and I know this came up as a question in the chat, where we're trying to drive a freeze forward, like say we're settling a case and this is the way the family's decided to settle, and the corporate minute book is, shall we say, sparse in terms of what's in it. We hand off to our corporate lawyers. They do what they fondly refer to as a coopering up resolution, where they lay out all the things that should have been there that aren't there, and then have everybody sign off on it. And by everybody, I mean all the current and previous directors to the extent they're still alive, and all the current and previous shareholders to the extent that they are still alive. Again, if you're settling a case by doing something like that, you have to think about who needs ILA, because just because somebody says the freeze happened 10 years ago doesn't mean it happened 10 years ago. The other thing you need to look at when you're having that minute book review done is the resolutions that fix the values of the pref shares had better line up with the filings with the Canada Revenue Agency as to what the value was. We've certainly seen cases where the valuation did not line up, and what it developed had happened was the incorrect number of shares were issued on the preference shares, so that accidentally value had been left behind in the common shares, which created a giant mess, what I like to call tax Armageddon. So again, the principal point for you all to remember is get the minute books, get them reviewed, and please, please, please remember that just because the audited financial statements say that the share capital is a certain number of shares does not make it legally so. It's what is in the minute books that makes or breaks what the issued shares are of a corporation. So with that cautionary tale, and having now identified a bunch of ways where lawyers and accountants can mess these freezes up, which is just an opportunity from a litigator's perspective to sue everybody and to increase the number of pots from which to claim money, I'm going to toss it back to Jonah, who's going to talk about standard of care for the professionals. Over to you again, Jonah.
Thanks, Claire. And maybe what I'll do just as a precursor to this, because we talked about getting the minute books early, is it might be useful to start off this discussion with a conversation about limitation periods. And so I want to jump to that first and just remind everybody of Section 38 of the Trustee Act, which is a hard 2-year limitation period that determines that there's a strict 2-year limitation period set out in that statute that applies to any actions involving claims in relating to the estate. This came up in a case called Ingram and I apologize, I may mispronounce this, Kulnick, it's an Ontario Court of Appeal decision 2024 ONCA 678. And in this decision, the Court of Appeal determined that this 2-year limitation period under the Trustee Act applies to actions involving real property. So accordingly, the 10-year limitation period that is provided for under Section 4 of the Real Property Limitations Act does not apply. At issue in this decision was whether an equitable trust claim brought more than 2 years following the death of the deceased should be limitation barred or statute barred. And the court goes on to conclude that Section 38(1) of the Trustee Act is more specific than Section 4 of the Real Property Limitations Act, and therefore applies to equitable trust claims. So all of which is to say that when you're dealing with an estate freeze and transfers of property and issues relating to transfers of shares, there is a need to be proactive and mindful of certain claims that may be brought against solicitors or in the context of negligence as raised in an estate freeze. So with that, I'm going to circle back and talk about the specific standard of care. And in this case, we know that the central authority comes from Central Trust and Refuse, a Supreme Court of Canada decision from 1986 that's still good law. And the two-part test when it comes to standard of care involving solicitors is, one, the existence of a duty of care owed by the solicitor to the party claiming negligence, and two, a finding that the solicitor's actions were a departure from the applicable standard of care, being a reasonably competent solicitor. So the first question is perhaps less obvious than you might think in the context of an estate freeze that I'll come to in a moment when we talk about the Blake decision. And the second question really dovetails with this ILA issue, both to whom it is owed and the scope of ILA to be provided. And before we get further into that front, I just want to make a general point that the solicitor's dockets are going to be something that is very critical when assessing a solicitor's potential negligence in this case. So when a claim in negligence is advanced against a lawyer, the lifespan of their involvement and their advice, subject to anything that shouldn't be in there because it's covered by solicitor-client privilege, should be covered in the docket. So a lawyer really has no place to hide his or her mistakes once they disclose their dockets in terms of the advice that they provided over the course of the file. And for example, you might, just to take a humorous example, you might find in this case, in this scenario, that the lawyer has a docket that says, reviewed Wikipedia for estate freeze. And if you're the litigator on the other side of that, you're going to have a field day with dockets like that, because it's going to reveal that, hey, maybe the Wikipedia article kind of lines up with their reporting letter, and there's not really a lot of dissimilarities between the two. So that's going to be an important consideration. So getting the minute books and the dockets early in order to preserve limitation periods and preserve rights is going to be very important in this case. And before I venture further, I just want to turn it back over to Claire to talk about corroborating evidence and Section 13 of the Evidence Act.
Sure. So just before I do that, can I encourage all of you also to make sure you look at the time periods on the dockets, not just the narrative descriptions. Often the narrative descriptions are pure gold of the kind that Jonah just described. But the other reason they can be excellent for you in cross-examination is when it shows that, in this case, the lawyer only spoke to Otto for point 2 in respect of the risks about this freeze. That's not going to be good for the lawyer. And similarly, if you're giving ILA, you better have a docket that's longer than 20 minutes long, because otherwise I'm going to be saying to your law pro counsel, there is no way there could have been a complete explanation of what the risks were to Rachel in agreeing to this freeze in 20 minutes. Like, that just cannot be done. And so please make sure you look at it. I always have somebody in our office add up the total number of hours spent on a matter. I always have them look at how much time it took lawyers to do particular tasks. For example, let's say you have a note you were reviewing Central Trust and Refuse, which is a Supreme Court of Canada decision that runs, I think, to 50 or 60 pages. If you reviewed that in point 1 according to your dockets, I'm going to make fun of you when I cross-examine you, because I know you only read the head note and maybe not even that. So that's the tip on that. So Jonah asked me to speak next about Section 14 and Section 13 of the Evidence Act. So this comes up if you're litigating a case where either, let's say, Otto is now incapable and Rachel is bringing a claim to unwind the act. Unwind the freeze. Otto cannot have judgment made against him unless there is corroboration of what it is that Rachel is asserting. So if Rachel wants to say that Otto told her she didn't need independent legal advice, and that for that reason she didn't go and get independent legal advice, and that's why she should be permitted to seek an order declaring that the entire transaction was invalid or was obtained improperly in an unconscionable fashion, there will have to be corroboration of her evidence in that regard. And just following that example, it may be that the corroboration is in the notes of the lawyer acting for Otto, who's noted down, told Otto to speak to Rachel about ILA. So that might be sufficient. Similarly, so that's Section 14 of the Evidence Act. Similarly, Section 13 of the Evidence Act, if this lawsuit all gets started by Becky after Otto has a heart attack, potentially when his lawyer tells him that he has to deal with the Becky situation and Rachel's going to find out. So now Otto's dead. Then nobody can get judgment against his estate under the Evidence Act unless there is corroboration of events that are said to have occurred. So your word as a witness is not sufficient. There's a bunch of case law that you should all get familiar with if you're in either of those situations. So, Jonah, I think then that means when I'm handing back to you, just to have a quick run through the question of lawyers and accountants failing to coordinate and what hay we can make out of that, and maybe a quick dip into the law on undue influence. I know it's in our handout, but just give a high-level review.
Sure. So just turning to some of the cases that are applicable in these professional negligence contexts. So one important thing to bear in mind is that and this isn't a case where there was a finding of negligence against the accountants, but there's just a recognition by the court in Giuliano, Blake and Castles, and versus Blake's, Castles and Graydon, 2016 ONSC 7932, where the court did address the dual responsibility and potential liability of lawyers and accountants with respect to an estate freeze. And in those circumstances, it's expected that the lawyer and the accountants are going to collaborate in terms of the estate freeze. So there's going to be accounting and tax concerns. There's going to be legal concerns. If one hand doesn't know what the other hand is doing, that's going to be a potential problem over and above the lack of, or over and above, or in part bleeding into the lack of independent legal advice in these contexts. So that's just a first point to bear in mind. So if in this scenario, the lawyer is doing nothing but reading Wikipedia and not actually engaging with the accountant to understand the tax implications of an estate freeze and their adverse tax consequences in implementing it, then that's another issue that could arise in a negligence claim. But more specifically, when we're looking at certain estate claims and allegations of undue influence, or that the client didn't have appropriate legal knowledge, there are various cases, including one I want to talk about in particular, which is Vincent and Blake. This is the 2013 decision, ONSC 980, where the son of the testator brought a professional negligence claim against the solicitors who drafted the will and completed an estate freeze. And the allegation by the son was, in essence, that the sister had unduly influenced his mother so that she would benefit from the freeze, despite the allegation that that the mother was intending to benefit both of them equally. And adding some color to this case was the fact that the solicitors in question had been the sister's professional advisors for a period of time. And there was a summary judgment motion, and the court, in essence, ruled that this was not appropriate. This is not an appropriate case for summary judgment because there is an argument that the lawyers in question did not owe they could have owed a duty of care to the son, unlike a situation where the daughter was the sole beneficiary of the estate. So there wasn't a trial decision that's been reported, but it just speaks to the first question under the refuse test, which is to whom the solicitor owes a duty of care. So that's an important consideration, and it adds into questions relating to when undue influence may play a role in potentially setting aside an estate freeze and ruling that it was not properly implemented or implemented with some coercion by another party who is benefiting from the freeze.
Jonah, just before you go on, I just want to interject and give one caution because I know we're getting closer to the end of our time today. If you are going to start an application to set aside an estate freeze, you better have got accounting advice for your client about what the tax consequences will be of unwinding the freeze. Because sometimes, and Jonah and I have had this sort of situation, you will discover that the tax Armageddon that will ensue will be so bad for the family that you, rather than actually starting proceedings, you can have a conversation with the opposing parties and use that as your leverage to get a deal.
Thank you, Claire. And just before I turn it over to Adam for his thoughts on independent legal advice for the spouse and children in the context of claims against professionals, I just want to add to that point in terms of procedure and speaking to this idea that you can bring these allegations or these claims to set aside an estate freeze. They're often done in the context of an application for a declaration that the estate freeze is invalid or should be set aside. But there's often, as you can imagine, these accompanying or parallel actions against the professionals where you have an application on one end, and then you have actions on the other, actions and negligence on the other hand. And there are times where, notwithstanding the fact that the application is going to dictate what happens with those negligence claims, so whether the estate freeze is set aside or not, the court may nevertheless order everything tried together, and then you could have this global discovery process where you have parallel negligence proceedings rather than a stay of one or the other, and you have these global discoveries and these trials that can become these very lengthy and costly processes. So to Claire's point, you better make sure that you have done your due diligence and your homework before you embark down that path. And that can have related concerns as to whether there is some urgency. Some of these cases have some very significant urgency contexts that need to be considered that will dictate how you proceed and how quickly you proceed. So I just, before we conclude, I just want to give Adam an opportunity to add any further thoughts in terms of independent legal advice for spouses or for children in these contexts.
So one of the things that a lot of clients can really groan and sort of go, well, why are you saying this? In the context of independent legal advice, it's often a good idea to get marriage contracts in place, essentially setting out what the intention is in terms of the next steps of the family structure. You might not strictly need that because, if it's gifting to a child or their interest in a trust is being gifted to them, it's excluded. But highest and best is to have a contract that everybody, the various spouses, are signing on to at the right level so that everyone at least knows what's happening. A good example of that actually in the checklist is the McNamee and McNamee case. So in that case, essentially, surprise, surprise, the husband finds out he's been gifted a bunch of shares. great for the husband. But there was really not a lot of paper saying that that's what was going to happen. So there were all sorts of arguments about what had been the intention in the transferring of these shares. And, at the end of the day, the husband does get his exclusion because it was a gift, but that could have all have been avoided if there had just been a couple of marriage contracts, better sort of record keeping at the time to really say, this is what we are. We as a family are doing X. This is the plan. A, B, C, D. Everyone impacted by this plan has been fully informed and signed on.
So I think with that, David, we're kicking it back to you. I think we've got about 2 minutes left, which probably isn't enough for questions from the floor. But what I did want to make this offer, which is, David, as you know, because you and I have known each other a really long time, this is a very collegial bar. And if anybody has got a situation where they're dealing with a freeze or where they feel like they've just put their head in a blender and pushed pulse, which is sometimes how I feel when I look at these cases, feel free to pick up the phone and call one of us. We can have a no names discussion before you decide if you actually needed to retain us to get more extensive advice. But I'm happy to give, speaking personally, some estate freeze therapy if that's helpful.
Thank you, Claire. I think that's a wonderful offer, and I would really encourage anyone to take you up on it. And generally speaking, in dealing with technical matters like this, to reach out to people with experience, senior members of the bar. And for junior lawyers that are here, I think that you'll find that most people are very, very welcoming and are happy to help you. The other thing that I wonder about is whether there's scope for a class action suit against Liquid Paper for failing to warn solicitors on its proper use.
I don't know, but just to interject there, David, if anybody wants to have a good laugh, next time they're south of the border, go into a Walgreens and read the back of a shampoo bottle and ask yourself what class actions have done to labeling in the United States.
I would like to thank all of our speakers for taking a horrendously complicated technical subject and reducing it to a series of very easy to understand, well-explained points. I think today's seminar was absolutely wonderful, and I hope that you've profited from the wisdom of our speakers. This is the last seminar in the series. I'm not sure what the next one will be, but we'll announce it soon. If you haven't downloaded the certificate of attendance, please do so. If you haven't downloaded the helpful chart that our speakers have provided, I would certainly encourage you to do so. Thank you very much, everyone. We're out of time. Have a wonderful day, and we'll all see each other soon, hopefully. Bye-bye.